So today I will explain how to make a contract. Making a contract is an important task and it should be done only after thinking about the relationship that you want to build with the other party. Don't fall into the trap of thinking that you don't need a contract. Even if you make business with a family member, and I would say in particular if you make business with a family member, you do need a contract. So let's learn how to draft one. Let's see how to draft a contract in 3 easy steps. The first step is the introduction, the first part of the contract. Most contracts follow the same basic format. They begin with an introduction, which identifies the agreement through a title, like for example sale agreement, and include date, names, and addresses of the parties, object of the contract, details of the goods that you are selling, or scope of work if you provide a service, price of the goods, or fees for the service that you are providing, and duration, in other words, for how long the contract is made. Let's start with the first point, the date, names, and addresses of the parties. It is important to identify the parties. Let's take a practical example. Sale of goods agreement. You can see in this case that I have written at the very beginning the date of the contract, 18 of October 2016. You need to mention the day when the contract is made, and then you need to mention the name of the parties, like in this case. This is a sale agreement between the seller and the buyer, so you need to mention the name of the seller, the surname, the address. You can also mention the passport number or the ID number, and the same for the buyer. If one of the contracting party is a company, then in this case you need to provide all the details which may be used to identify the company. This is the first part of the contract. Then you need to mention the object of the contract, why the contract is made. In my example of sale of goods agreement, you can see under point 1, following the terms and conditions of the agreement, the seller agrees to transfer ownership and deliver possession to the buyer, and the buyer agrees to pay the price. So this is the object of this contract of sale. If the contract is another contract, like for example lease agreement, in this case you should say the lessor agrees to lease out the property and the lessee agrees to pay the rent. Each contract is different, so you need to mention what is the object. For example, let's take the employment agreement. It is a contract between employer and employee. The employee agrees to provide services to an employer in return for remuneration for the duration of the services. So this is what you should mention under this point. With regards to the details of the goods, you need to mention what are you selling. So for example, the seller wishes to sell to the buyer 20,000 red keychain with a bottle opener. So this is, in my example, the object which the seller is selling to the buyer. If you want to draft a different contract, you should mention the scope of work if you provide a service, which service you provide, or if it is an employment contract, what is the nature of the work. If it is a rental agreement, you should mention the type of property that you are renting out, like for example a house, a garden, a bicycle, a room. It depends on the specific case. The next point is the price, fees, that one party need to pay. If it is a sale of good agreement, it means that the seller sells the good to the buyer in exchange of the price. In this case, you can see 10 baht per unit. You need to mention how much is the price. It must be clear. So, in case of doubt, in case of conflict, in case of dispute, everything is written in the contract. If this is not a sale of good agreement, if you want to draft a different type of agreement, like for example, employment contract, well, you should mention under point 3 the salary that the employer pays the employee. If it is a rental agreement, you should mention the rent, how much is the rent. If it is a loan agreement, you should mention the percentage, the interest rate. This is the point number 3, which applies to this contract. Next point is duration. If it is a sale of goods agreement, you need to write when the buyer need to pay the price to the seller for the property that the buyer has purchased. If it is an employment contract, you need to write when the employer need to pay the salary to the employee. If it is a rental agreement, you need to write when the lessee need to pay the rent to the lessor. The next step is the major terms of the contract, the main part of the contract which define all the rights and obligations of the parties. This is a very important part. First, you need to mention in the contract the obligations of the parties, termination of the contract, in which case does the contract terminate, and the breach and damages, what is going to happen in case of breach of the contract, how much are the damages. So let's start from the first point. Obligations of the parties. What are the obligations of the seller? What are the obligations of the buyer in a sale agreement? What are the obligations of the employee? What are the obligations of the employer in an employment contract? What are the obligations of the lessor? And what are the obligations of the lessee in a rental agreement? So each contract has different rights, different obligations. The contracting parties, they have different duties. Let's have a look to the obligation of the seller and the buyer in a sale agreement. You can see under point 5 the obligations of the seller. The seller must be the sole owner of the goods. The seller has the full right, power and authority to sell the goods. Neither the goods nor the manufacturing process infringe intellectual property rights. And then letter D, the seller has no reason to know of the existence of any title or claim to the rights over the goods. It means that the seller must be the owner of the goods. The seller cannot sell the goods of someone else. And then under point E, the goods will conform to the description and specification made to the buyer. They must be free from defects in material and workmanship. Then under point 6 you can see what are the obligations of the buyer. For example, in this case you can see that the buyer certify that the agreement constitutes a legal, valid and binding agreement. The buyer must pay taxes and any other governmental charges imposed under the law. Under point 6 you find all the obligation of the buyer. Then point 7 specify all the details about delivery of goods. What is the date of delivery of the goods? What is the location of delivery? The notice. Does the seller need to inform the buyer in advance about the shipment of the goods? And then point D, risk of loss. What happens in case of damage, loss or delay to the goods? What happens in case of damage? What happens if the goods are lost? What happens if the buyer receives the goods too late? Who is going to be responsible for this? In this contract that I show you here is the seller. But you need to provide all these details depending on your needs. And then the last point is point 8. What happens if the goods are defective. In other words, if the keychain are broken. What happens if there is a defect? Who is responsible for this? You need to mention all these points under this paragraph. Termination. In which case does the contract terminate? Termination. When the contract can be terminated. It is important to specify cases where the contract can be terminated. So, either party under letter A can decide to terminate the contract by giving a written notice to the other party. It is important to say how many days in advance, 10 days, 20 days, 1 month in advance. Under letter B, either party can terminate the contract for a material breach. So if the other party does not perform her obligation under the contract, it is possible to terminate the agreement. Let's take an example. If the buyer does not pay the price, in this case the seller has the right to terminate the contract. Then under letter C, you can see that either party at any time without prior notice can terminate the contract if the other party goes bankrupt. So if the seller goes bankrupt, the buyer may decide to cancel the contract, to terminate the contract, and vice versa. So for each type of contract, the contracting party must write the cases of termination when the contract can be terminated. Then the last is breach and damage. This point is very important as well because you need to understand what happens in case of breach of contract. Who is going to pay for damages? How much are the damages? What are the potential liabilities which may arise from the contract? In other words, this is point 10. What is breach of contract? What are damages? Depending on the contract, you may draft different sections, different paragraphs. In this case, you may write, for example, what happens if the goods, the keychain, do not conform to their description? If you remember before, I told you that keychain must be red color. What happens if these keychains are not red? What happens if they are green, for example? What can the buyer do? Can the buyer sue the seller? Can the buyer get damages, compensation? Can get the money back? Yes or no? This is why this point is very important. You need to draft this point very carefully. The last step is step 3, the concluding part. At the end, you must specify the law which applies to the contract. Like for instance, American law, French law, Thai law, which law applies to the contract, which law governs the contract. The making of a duplicate. The contract must be made in 2 copies, one for each contracting parties, and the signature of the parties. Both parties must sign the contract. Let's make an example about this last point. Governing law. This agreement shall be governed by Thai law. So it is important to mention, in case of dispute, which law will apply to the contract. Duplicate. This agreement is made in duplicate. 1 copy for the seller, 1 copy for the buyer. And at the end, you will get the signature of the parties, the seller and the buyer. If the seller is a company, you need the signature of the corporate official and you need to mention what is his title under the contract. So these are the main points that must be clarified in a contract. A contract deserves attention and it must be drafted in a very, very careful way.